Hi guys, it's Kathy. I hope you're doing well. Yes, I have cat hair on my shirt because you want to know why? I have a cat and I pet the cat and the cat gives me hair on my shirt. And someone I lived with stole my lint roller, which is fine because I have cat hair on my shirt because I have a cat. And I'm in my own home right now, so I can have cat hair on my shirt. Yeah, that's right. I'll find my lint roller. I'll find who stole it. And I will have cat hair tomorrow. I'm not changing my shirt, though. Heck no. Okay. Maiko starts the day off right. Thank you, Maiko. I appreciated that comment. So, I think I'm going back to my judges after this is over. I'm having fun. I really am. I love this case. I love the two before it, but you can only see my judges here. Oh my God, Jassie's here. Hi, Jassie. And if I'm not playing my judges, nobody can see the judges at all. None of the judges that I play. No one gets to see them at all because no one else shows them. So everybody's seen McDonald, which I'm glad I stopped and took the time to watch it because it's amazing. But I am going to my regular judges after this. Jazzy, how you feeling? You're gonna like this, Jasmine. If you haven't seen McDonald yet, you're really gonna like this.
Good afternoon. We're back on the record. The plaintiff was on the witness stand. Mr. McDonald, would you like to continue with your examination of the plaintiff?
Yes, Judge, I would.
All right, ma'am, come on back up to the witness stand. I'm going to remind you that you're still under oath.
Just to recap. All right, if you just walked in, the man who is about to question the woman on the stand, they're going through a divorce. That's the husband. Crazy, 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 crazy. And she's the wife. Sane and grounded and beautiful. And anyway, he had 3 hours for his trial. He had 3 hours. I think so far he's used 2 hours up of it already, which means he's pro se. So if he wants to testify himself, he needs time to do that. This is he's going he just used 2 hours. He's going into his third, just questioning his wife, and absolutely zero that he questioned her about is admissible. So it's entertaining though. So we're all like kind of freaking out that he's using up all of his time. He's gonna run out of time. He's gonna run out of time. Well, here we go. We're He's got 1 more hour to go. He still has plenty of time to testify if he shuts up right now.
Mr. McDonald, I told you at the break you have about 1 hour left. Continue.
Well, Judge, before we start with the rest of the witness, I would like to admit these exhibits into records so that we can use them and finish the trial here. So,
Counsel, do you have any objection to any of his proposed exhibits?
I do, Your Honor.
Okay. Can you stipulate to admission of any of his exhibits?
We can stipulate to exhibit A.
A will be admitted. And counsel, tell me what Exhibit A is. The copy I
Hi,
have is
Smith.
not...
Municipal court document showing 15 domestic violence classes completed.
page 5.
Hi, Budgie.
All right, A will be admitted, less the typewritten information at the top, that will be stricken.
Judge, can I stipulate to that the Safe Nest classes being completed, and there's the Safe Nest book is Exhibit B.
Can you stipulate to it?
Can we enter it into record?
We won't stipulate that, Your Honor.
There has been completed domestic violence classes intake and domestic violence classes.
What I will allow is this picture of what appears to be a book, Alternatives to Domestic Violence, a homework manual for battering intervention group, 3rd edition, will be admitted. I will give it the weight that's appropriate. I am striking the typewritten sentences above the picture. Proposed Exhibit C. Counsel, do you have any objection?
Yeah, because I've never seen that. I've never had a chance to depose or talk to the counselor. She's not here to testify as an expert witness. She was never disclosed as an expert witness.
She is on vacation, Judge, and I have disclosed this to counsel and let them know I've been in counseling since leaving jail.
I'm real concerned about this letter. It seems as though the font is changed in a certain part. Despite counsel's objections, I'm going to allow it. I'm striking the language at the top, Exhibit C. It is a hearsay document. I am concerned. It looks as though at the first paragraph, there's a change in the font. I do not believe Mr. McDonald is a harm to his children or himself. Seems to be in a different size font than the rest of the letter. As to Exhibit D.
The same objection, Your Honor. We did not get a copy of this until this exhibit binder, or the exhibits were produced to us on March 14th. We've never had a chance.
March 14th. It's March 16th right now, and this is trial. And he just gave them this. I think, but I'm not sure. I think this is going against his time.
To meet with Mr. Harder to discuss this, to depose him, to prepare any type of supplemental expert report. And so for that reason, we'd ask that it be stricken.
Mr. McDonald, your response?
Judge, this was I don't believe there ever was a mental eval ordered except for Judge Almasi, there was one done while in jail with psychologist Green. This was done as a way as a means to just show the court that I am of sound mind in case that is needed. I believe it was sent to the opposing counsel when it was completed.
I'm going to allow it. I'm going to strike the written notes at the top. I'm going to note that this report is dated August 24th, 2016. Judge Hardcastle
Bren, thank you
ordered
so much.
On November
Yeah, hope you're
29th,
doing well.
2016, months after this is dated, the psych eval. So this does not, I'll admit it, it predates, I'll note, my written order, so I'm not sure that it's relevant or that I can consider it under the mandates of McMonigal and Castle. However, it'll be admitted. Exhibit number C.
E, Judge, is the
I'm
appellate.
sorry, E. Counsel, any objection?
No objection, Your Honor.
And that's the appellate brief on the.
All right, Exhibit E will then be admitted without any objection. I'm going to strike the typewritten language on the top, on the first page. All right. That gets us to Exhibit F.
As long as it is similar to the other ones, we have no idea what this is or where it was, there's been no testimony about.
I'm going to strike I'll admit the exhibit. I'm going to strike the typewriting at the top. Mr. McDonald, do you understand what I'm doing? This, where it says Exhibit F, divorce care classes at the Crossing Church, which defendant would go to on Wednesdays. It addressed parenting and other issues on coping related to divorce.
There should be a synopsis or something.
Just so that you know, that is what you wrote on here. You wrote Exhibit F. So this is a picture of what appears to be a book.
Is there supposed to be a summary for each exhibit? I'm unfamiliar with the
I
process.
understand. I'm just striking that language. So what admit is the picture of this book, okay? What you believe it stands for or what you think it is, that's up to you to tell me in a different way, not through this picture. Exhibit G is a copy of the 12 steps in a prayer for serenity. Any objection, counsel?
Same objection. We don't know what it is, and there's been no testimony as to what this document is.
It'll be admitted despite the objections, and I'm going to strike the writing on the top. Exhibit H.
These are articles and different studies on the CAP study and different things that for parental alienation, pathogenic parenting. It says it is relevant to this case in regards to what's in the best interest of the children and the deep-rooted psychological issues that are caused by parental alienation and pathogenic parenting.
Okay, let me ask you, 27 seems to be just some sentences describing what the exhibit is. 28, 29, and 30.
Those are different societies and different...
28, 29, and 30 just seems to be a list where the font is changing quite a bit, where there's a list, where there's nothing listed for number 2. Is this something you wrote, Mr. McDonald?
No, it's not something that I wrote. This is where this is the expert reports and
Well, pages 28, 29, and 30 are not expert reports.
these are where these studies pertained and where they came from. These statistics.
Who wrote down the words on 28, 29, and 30?
They came from various groups, from Restoring Freedom and different groups that the Family Civil Liberties Union and other.
Do they routinely make lists that skip numbers 2, 7?
I think I may have copied it a little.
17. It's not a copying thing. I mean, this. I'm concerned that this is there's no foundation for this document. There's a lot of errors in this document. It appears to be a list that is not complete.
This is just where where the rest of the exhibits and statistics came from, and to give it merit, Judge. Of the different experts within this field of psychologists and statistic professionals.
Okay. You can't tell me where 28, 29, and 30 came from. It seems to be like a strange list of things.
This came out of a report that we actually, it was copied out of a report.
Who's we?
Me and a group called Restoring Freedom and Family Civil Liberty Union.
Okay.
We presented to Congress. And
So this is something you did write?
No, Judge, I did not write this. Other people have written this.
Other people?
Experts have written this, yes.
Experts wrote this list?
Experts.
They wrote the list of where these statistics and things come from, so yes, Judge.
Okay, I'm going to admit it and give it the weight that is due.
The ACE study, 34.
Experts.
Okay, well, what
wrote-
about 31, 32, and 33? Counsel, any objection to that?
Again, Your Honor, it's hard to say where these are from, who drafted these, what
If you took in what he wrote, then you got it.
bearing they have it all on a modification. He's under a burden to show why there's been a change in circumstances and why it's in the best interest of the children. These are simply screenshots of Facebook posts or whatever else they may be, but there's no indication of who did them, what they were for, how they have any bearing on here. They haven't been addressed in any.
Mr. McDonald, where did you get this 31, 32, and 33?
These were part of they were put through the Co-Parenting Alliance of America. The Time to Put Kids First is on 31. The Fathers' Rights Movement on 31 as well. 32 is the same thing. All these just give more statistics and different from the different studies of these groups that are working towards equal shared parenting, which is also a 501c4 that's working in Congress and various states and passing equal parenting legislation.
They all appear, Your Honor, to be things that may potentially be relevant at a legislative hearing, but they're not relevant for today.
All right, I'm going to allow them and give the weight that's appropriate. The ACE study.
This is the
Any objection?
Same objection, Your Honor.
I'm going to allow it and give it the, but I'm very concerned. It doesn't seem to be the ACE study in its entirety. There seems to be typos. It seems as though there's a lot of strange things in the font.
Sure.
I'm concerned
It's written in Mayan.
about who created this document and whether it is the entire document. The ACE study is much longer than that.
It is.
The number 40 is organizational chart for the family court cartel. How is that relevant to today, Mr. McDonald?
It's just relevant to show what happens in a lot of the divorce proceedings and how a lot of fathers in regard.
I think she's admitting it for completeness of the record. So that way, if he tries to appeal or anything, it's in the record that he tried to admit these crazy things.
To being cut out of their own children's lives, and there's a means to. It's a flow chart on changing it. If you don't.
Where did you get this from? Did you create it? Did somebody else
No,
create
Judge,
it?
somebody else created it within our organization.
What is our
The
organization?
Family and Civil Liberties Union.
Okay. All right. I'm going to allow it. Certainly, all of these are hearsay documents. There's no foundation about who created them and based on what. 41.
It's family, just relevance to what's going on and what happens in court and the false allegations, which I think is relevant to this case in regards to custody, and the 42 as well as the silver bullet in regards to false allegations of abuse, which are on appeal currently.
I'm going to allow it and give it the weight that it's due. Again, I'm concerned because we don't know who created the document or where.
These next ones were created by the Fathers' Rights Movement, which is in each state.
43 will be admitted. Counsel, I assume you have the same objection. All right, 44.
44 is the talking parents, where
Any objection,
feeding
counsel?
and trapping.
No objection to that being admitted.
It'll be admitted less the typewritten notes at the top. Exhibit J, counsel, any objection?
No objection, Your Honor.
It'll be admitted less the typewritten notes at the top, which will be stricken. 46. Any objection, counsel?
Just that it's irrelevant to this case, that it's been definitively proven that this isn't what plaintiff or defendant thinks it is. But if I believe Your Honor has heard the testimony. If you want to admit it, that's fine.
46 will be admitted. The typewritten notes at the top will be stricken. What about page 47, counsel? Exhibit L.
That's fine too, Your Honor.
All right, it'll be admitted. I'm striking the typewritten notes at the top. 48, same, counsel.
Same.
Proposed exhibit M.
That's fine, Your Honor.
It'll be admitted, less the typewritten notes at the top. 50.
Same.
It'll be admitted, less the typewritten notes at the top. 51, I think, is
It's just a
part,
continuation.
and so is 52. 53, enrollment in Key Real Estate School.
Yes, that's
Counsel, any objection?
Just again, Your Honor, it's not a document that we'd ever seen before. There's no
Wasn't
basis on
produced
who
in
drafted it,
discovery.
where this came from. It
We
wasn't.
don't know if it's really from Key Real Estate School. Oh, I know that you have a lot of objections, counsel. I'm going to admit it, less the typewritten notes at the top. All right, 54.
Same objection, Your Honor.
It'll be admitted, less the typewritten notes at the top. 55.
This one we will object based on the fact that this has to do with the property issues that are not relevant for this case.
Mr. McDonald?
Judge, I would like to just to have it admitted to show the relevancy to why there's a reason for the alienation and stuff is also due to money, and this is one of the situations of that. As you can see, the payout was a completely unfair amount and a lot of marital waste that happened. And I would also like to address this at a later time in regards to property at a later date.
So you're still seeking its admission today?
Just in relevancy to the custody today and also for the property.
All right, I'm going to admit it. Less the typewritten notes at the top, less all of the handwritten notes that are made on these documents throughout. And I will give it the appropriate weight. Page 62, Exhibit R, Counsel.
Q.
We have page 56, Your Honor. Exhibit Q.
Oh, I kind of went through. They're all relative to the house. I'm sorry, Counsel.
It's an appraisal that was done, allegedly done October of 2016. Again, same objection. It has no relevancy to a motion to modify.
I understand. I'll allow it. Now, 62, proposed Exhibit R. Any objection?
No objection.
All right, I am going to strike the typewritten notes at the top. 63, any objection?
Just again that it's regarding the property, but other than that, no objection.
It is irrelevant to today's proceeding. However, I'll admit it into evidence, striking the typewritten notes at the top. 64, proposed Exhibit T.
No objection other than the fact that it is the exact same as Exhibit R.
Might be a duplicate.
It'll be admitted, striking the typewritten text at the top. 65, Exhibit U.
We will object to this one as there's no description of what this picture is, when it was taken, what it's trying to depict.
So, Judge, this shows the property of the children.
Mr. McDonald hasn't laid proper foundation. We can go back to that if he does want to lay the proper foundation for that photograph. Proposed Exhibit V, page 66.
So the list of inventory.
Any objection?
Yeah, just the same objection that it's irrelevant for today's hearing, Your Honor.
I'm going to allow it, although it is irrelevant, and strike the notes at the top. Mr. McDonald's argument that it is somehow relevant to show her motivation, her monetary motivation for allegations of parental alienation. I'll allow it to that extent. 67, proposed Exhibit W. How is that relevant, Mr. McDonald?
The relevancy of this is that there wasn't a proper defense made by previous counsel, Kurt Smith. There was a fee dispute and a bar complaint that was issued, as there was no set time that was put in place before discovery. No discovery done. There was no preparation for.
Speaking of set time, dude, you are running out of time. I'm just going to stop real quick. Crystal Gore, hi. Thanks for your comments.
Trial by previous counsel, and I went to trial without ever meeting counsel and and that's why that is relevant, because there was a lot of evidence that wasn't presented at our original trial that I'm not able to present here, as it cannot be heard until.
This issue is not before me, but before the state bar, and fee dispute looks like it has been filed. It's irrelevant to today's proceedings. I won't allow it. As to 68.
The same thing in this one, Judge. And
This is your credit card authorization
so
for.
this was shown that there was $1,000 that was given, and there's $1,500 due. The court ordered that Mr. Kurt Smith get paid $3,500 out of the sale of the house, which was put in place, and also motivated. I don't know what the relationship, but as he wasn't able to present.
What do you mean you don't know what the relationship?
Relationship between yourself, Judge, and between I don't know why he was awarded that amount of fee when he was only owed $1,500 per the retainer agreement, and then he put a lien on the house.
Relationship between me and Mr. Kurt Smith?
There was things disclosed by him saying that you guys went to law school and all this other stuff. So
Mr. Smith told you that he and I went to law school together?
Something like that, yes, Judge. He made comments that he said that he does very well in front of you and things like that, which was one of the reasons why we retained him. Then he didn't do the job, so the reason behind this is just to show that.
Show that I'm biased?
No, Judge. I'm not,
Oh.
I hope that's not so. So.
I loved your comments
I'm sorry,
too.
what?
Thank
I
you.
I hope that's not so. This is just to show that there was improper orders. Well, there was.
That I
award.
maliciously awarded him $3,500?
He was awarded almost $3,500.
All right, this is
Hi,
not
Judy.
relevant.
The other
I'm
Judy and Judy.
not
Two
going to
Judys.
allow it for the same reason I didn't allow Exhibit W.
This is the next one.
69.
Order number 69 shows the amount of fees that Mr. Collins took out of the improper sale of the house. It shows that the fraud that was committed on the court in order to
Any objection, counsel, to 69, 70, 71, 72?
Just that they're not relevant and they're not complete. They're not complete copies of the.
It looks like they're pleadings, but they're not the full copies of the pleadings, so I'm not going to allow it to the extent that it doesn't represent the entire document. However, I'm going to take notice of any of the pleadings and papers filed in this case. Exhibit Y. Any objection, counsel?
Just again, it's dealing with property issues that aren't before the court today.
How is this relevant, Mr. McDonald?
It shows the malice intent to defraud the court to say that a refi wasn't approved to further alienate Mr.
I'll allow it. It'll be admitted. I'm striking the typewritten notes at the top. Exhibit Z, 74.
It shows the marital waste.
Hold on. Any objection, counsel?
Same objection. It's dealing with property issues. Your
I'll
Honor.
allow it. Striking the typewritten notes at the top and all of the handwritten notes throughout. 75. AA. Email from loan company.
Again, same objection.
Counsel, Mr. McDonald, same argument as why it's relevant?
Yes, Judge.
It'll be admitted. Striking the notes at the top. Exhibit AB, page 76.
It just shows the orders that.
These seem to be partial orders, partial pages with handwritten notes. That won't be admitted. Same with AC. Those are partial pages from court orders. The court will take notice of the papers and pleadings filed in this case. AD seems to be partial
Judge,
printouts.
I would like-
Counsel, any... Yes, Mr. McDonald.
Judge, especially Exhibit AC is in regards to custody, though, saying that the reasonable phone conversations, which that I would.
You have made a copy of one page of an order.
divorce
Is that
decree.
right?
Yes, Judge. I didn't
So
want.
I have the divorce decree.
Yes, Judge.
All right. So I'm not going to allow this
Oh, wait, you
one page of the divorce decree. I have the divorce decree because I signed it, and I said for about the 5th time I am going to take notice of all papers and pleadings filed in this case, so that you understand. Papers and pleadings includes everything that was filed in this case. The court will take notice of. I'm not going to let counsel try to admit a pleading because I already have it. I signed it. I know it.
Thanks for
I'm going to
clarifying.
look at it again just so that you understand. But we cannot take one page of a document ever. Do you understand that? So that's the other issue, okay? And then you can't just have handwriting saying what it says because the document speaks for itself, okay? I can read, and I can read the document.
Okay. Thanks for clarifying.
Exhibit AD. Counsel, any objection?
Objection in that we don't know.
I know why. I mean, it's like heady. Like when you meet someone like this and they give you their full attention when you're used to getting like half attention or part attention, and they notice everything and they're at the beginning happy and, can I go get you some coffee? Or, they're so focused. It's like, it's heady. It's not what you're used to. So I get it. I get it. And then slowly it turns way different.
We don't know what vehicles he's put. These are Blue Book values for vehicles, so it's.
Well, we don't know.
issues, and
We
don't
assume
know-
it's Blue
we don't
Book.
know what's.
These were the Blue Book values that weren't included in the discovery or the previous trial that shows that the plaintiff was awarded an improper distribution of assets, as there was over 15,000 in.
So it's irrelevant as to custody, but you think that it's relevant as to her parental alienation based on her
Well, there was a lot of
quest for more money?
there was a lot of conversations between the cars and the disparity of that.
All right, I'm going to allow it. I'm striking the notes at the top. All right, 79.
This shows the.
Hold on, any objection?
Objection in that I can't even tell what this picture is showing, Your Honor.
There's been no foundation laid. Mr. McDonald may want to return to that and set up a better foundation.
Yes, Judge.
As to page 80, Exhibit AF, any objection?
Again, it's hard to read exactly what these are.
I can't really read the handwriting on there. Mr. McDonald, there's not been foundation laid, but you haven't testified yet, so I'm going to set that aside, and you may wish to return to that. Exhibit AG, letter to Michael from Candace. It's undated, Ms. Counsel.
Yeah, just the fact that it's undated, it's hard to say where this is from, what it was about, when it was actually written. There's been no foundation for it, Your Honor.
I'm going to not rule on it yet. Perhaps a better foundation through Mr. McDonald's testimony. Exhibit H, receipt from paying the daycare by check as ordered by the court.
And again, Your Honor, it's impossible. I can't read at all what the receipt, other than so it looks like $586, but other than that, there's nothing. I can't read anything else that's on that.
This is the receipt for the check that was ordered by this court.
Well, it looks like a receipt from 2/5/2016 for $586, but I can't tell from whom. So I'm not going to admit that. It's too blurry to make out anything.
Let's say Michael McDonald and then New Horizons Preschool on the
I
left.
can't read that.
Judge.
I see nothing. It's all blurry. I see McDonald, 586, but it's a very, very blurry picture.
Yeah.
Exhibit AI, page 83. Counsel.
Again, pictures with no foundation.
All right, I'm going to allow those. 84, proof of service. All right, there we go. All right, Mr. McDonald, you want to continue with your...
Yes, Judge. So,
all right, go ahead.
So I last left off on some of the exhibits, in which I'd like to go through a few more with plaintiff here.
Okay.
So on exhibit page number 50 here, that is the stalking that she has been perpetuating through social media.
I'm looking for a picture that I want you to show Louie. I'll find it in a second.
Yeah, and having her friends go on and make various comments and defamation against myself and others. Also posting different things and having a radio show ex-radio show DJ go and further cause damage in this court, and it shows the stalking that she has by joining these various groups.
Oh, so are you telling me something? Or are you asking
Okay.
questions?
So is this not a post from you?
I can't see that.
On page 50, can we
Well, hold on, Mr. McDonald. What page are you looking at?
page number 50? It's the post in exhibit
Hold on.
M1.
Let's all get it. Let's all get there. Give us some time. Okay. Number 50. 51. 52. All right. Joe? No, you stay there.
I can give her.
Oh, all right, counsel. Yeah, counsel, you could help her with it. All right, go ahead. Ask the question you want to ask.
Is this you posting in the various groups that I belong to, or that have you had? Is this you right here that you posted? This shit keeps getting better.
I honestly can't read. Like, it's so small. I may have posted that, but I don't know what it's in relation to. I can't even read any of the writing.
So do you admit that's you, Candace Rink? It shows a picture of you and Joe.
That's actually not my Facebook account. That account had to be closed, and that's not my Facebook account. I have a Facebook account, but it's under a different name.
You have two Facebook accounts, is that correct?
I have one Facebook account that I use.
Who posted that then?
I may have posted that, but I don't know when. The last time I accessed that Facebook account was, I don't even know. It's been a long time.
This was, let's see here, exact date might not be. October 10th it says here. So that's
What page are you looking at?
Page 50.
Where does it say October 10th?
It's very small, right below the oops, hashtag oops. There's a date there.
I don't see a date. I see hashtag
You have to
oops.
really squint to see it. It's really,
There's not a date. Counsel, is there a date on yours? There's not a date on mine.
says under Sanson, you can see October 10th right there.
Oh, under the, okay.
Yeah. So, let's go to the next exhibit. So this is Blair Rimmenschneider. Is that a friend of yours?
Is this on page?
Page 51.
Blair is a friend of mine.
Did you have Blair go and make libelous or comments about?
No, I'm not in control of what Blair does.
No, you didn't have him put different.
No,
or
I in
go
fact
soft-
have asked. No, I've actually asked my friends and family to stay off of any social media.
Okay. On page 52, she's saying things about the stability and different things, being a sperm donor. Do you agree with that?
I'm sorry, I'm not seeing where you see that.
Where are you at?
October 30th at 12:04 p.m. You've done nothing when it comes to helping bring them into the world. Nothing. You were basically a sperm donor.
Do I agree with that statement? I mean, I don't agree that she said that to you. And I mean, my personal opinion, you were more than just a sperm donor. I certainly would never encourage anyone to say that.
Is Mr. McDowell a good father? Does he love his kids? Does he teach them? Love them?
If you're asking me if I think you are a good father, the answer to that is no.
No. Why?
Just because of the level of things that you've done and said to the kids and the ways in which you're
Not a good father during the marriage? Maybe
during the marriage. I think that there were points where you tried to be a good father, but I think ultimately your abuse towards me made you not a good father. The things that you exposed the kids to, I still believe that you love the children. I just don't think you know how to act appropriately with kids, and I think that doesn't make you a healthy parent for them.
Did Miss Riddell not go to the help you with your center and with those kids and work with kids in a volunteer situations and
Are you talking about before we were
You worked
married,
at
when
Club
I was
Christ.
working at Club Christ?
Yeah.
I think you did volunteer on a few occasions, but that doesn't have anything to do with your parenting.
You said that Mr. Riddell doesn't have experience with kids and isn't-
I didn't say that you didn't have experience with kids.
Let's go with 50. The real estate school is for. We can just skip those here. So one thing in regards to page 55. Did you go into the house right after Mr. Riddell got thrown in jail?
Did I go into the house?
Yeah.
No. After you were put in jail, no.
Who went into the house?
Well,
The window was broken and the doors were torn off. The door.
well, I certainly did not break a window or a door in my own home.
That you haven't been in for 2 years.
I'm sorry?
And,
I didn't hear what you said.
so was there a window broken? Was there a door?
If there was a window broken, it wasn't anything that I had knowledge of.
Are you currently in possession of the DVR hard drive for the camera system?
I'm not in possession of anything from the
Is
house.
Mr. Collins in possession?
I don't know what Mr. Collins is in possession of.
So there's a list of things that we could bring up here, but that would show. I think there's a hard drive listed on that as well into what happened. Where is Marley at? The dog. Is she okay? Is she still alive?
Yeah,
Did you take?
I have Marley. My mom picked her up because she was there alone, and those are the kids' dog. That's the kids' dog. I still have her. I'm taking care of her.
She's still alive and good. Mr. McDonald's stepdad went there and couldn't find the dog, and the house was broken into. So after that, there was a day that Saturday, I believe. What did you not go with your parents and start throwing things in bags and it was all thrown out in front of the street?
I'm sorry. Can you ask me again?
Were items taken out of the house and thrown in bags and put on the street?
Honestly, during that time, my parents handled a lot of that. My attorney was present. We made my parents made sure that they took pictures. It actually was really traumatizing for me to be anywhere near the house, and so they handled almost all of that for me, so that I didn't have to be subjected to all the things that I was subjected
Mr.
to.
McDonald's work inventory and technology thrown away.
My parents handled all of that. My parents interacted with your brother. And honestly, I was so overwhelmed with everything that they handled everything for me.
Who broke into the safe?
I don't know.
Your
I
Honor,
don't know.
My objection that this is irrelevant.
It's relevant
For today's hearing.
Well, Mr. McDonald, I assume that your argument is going to be it's somehow relevant because mom is trying to alienate the kids from her, from you, and that she has some sort of financial motivation to alienate the children from you.
Yes, Judge. That's the.
All right. I'm going to allow this to continue. You have approximately 50 minutes left. I have yet to hear any testimony from you. So if you want to testify, as I stated at the beginning of today, and before we broke for lunch, you need to keep that into consideration. You have 3 hours. You've used 2 hours and 10 minutes through your examination of her. If you would like to testify and tell me your side of the story, you need to reserve some time to do that.
Okay, I wasn't aware of that, Judge.
I told you at the very beginning. I told you when we broke for lunch. I'm telling you again now.
Okay. So the items in the safe were the kids' college funds, or are you in possession of that? The $800.
I wasn't aware of any kids'
gold, silver, awards, medals. No.
I really can't testify as to what was in the house because I didn't even handle any of that. My parents handled that.
What did the neighbors see you guys taking out property?
I don't know what the neighbors saw.
And saw you and Joe. Was Joe with you during that time?
I told you my parents handled everything for me.
Okay, did you get almost $60,000 out of the sale of the house?
The proceeds that were paid to me were $39,000. There was some back child support that was awarded to me because of the lien on the house. Or it was a judgment. It was a judgment. It was reduced to judgment, which is why more money came. And then my attorney was awarded $23,000 for attorney's
Was
fees.
the house ever listed?
Was it listed?
Was it ever listed with realtors? What was it listed at?
Yes, I had a realtor who listed the house.
Was it listed at market value?
Yes, he pulled the comps from around the house and took into consideration the condition of the house, which was not.
Did your counsel ever see the appraisal report that was sent to him? Did you ever see that?
Objection, Your Honor. She can't testify as to what her counsel saw or did.
It's true, Mr. McDonald. She can only testify as what she knows.
Were you aware that the house was worth over $165,000?
That it was worth.
It was worth way over $100,000.
It was worth 100 and it sold for 165.
And then
So yes, I was aware that it was appraised at 160 and it sold for 165.
And your mom was awarded $1,300 for a dumpster fee, and also got locksmiths and stuff like that. Are you aware of that?
Yeah, you had your parents change the locks multiple times after I had an order from this court saying that I was allowed to enter the home and sell it. So yeah, we did pay for the locks to be changed back twice.
What did you do with all that money?
That was given to me, or
It was taken from the.
that was split between us? Because you got your half, but your half went to my attorney.
Do you think it's an equitable split?
It was literally split in half. It was split in half, and your portion went to your old attorney, whom you did not pay, and you were ordered to pay my attorney's fees because you have a need to drag me back to court every couple of months. So yes, I think it was equitable, and unfortunately, you chose to go this route, so that's what you did with your money. And what I did with my money that I was awarded, that's what you're asking me. I paid off the $16,000 in credit card debt that I incurred when you didn't pay child support or medical bills. I bought the kids groceries with that, so I paid off that debt. I paid off my car, and I put a small down payment on a new house.
What happened to the marital car?
I traded it in for a car that was that I could completely pay off, so I didn't have to have monthly payments.
Well, let's go to other exhibit here. So this is the appraisal report, Exhibit Q. We'll go there.
See, Bren, you should bring Louie over for a play date. Look, Sophie wants to play with Louie. Please. They would be so cute. Oh my gosh.
Let's see. This is the appraisal value over 205, 210.
What page number are you looking at, Mr. McDonald?
I was going through the report 60, 70, 61.
61?
I mean, it's 59 through.
Oh,
Through
59?
the different comps in the area.
Okay.
Yeah, if you look on page 58, there's a bunch of 209, 185. There's different comps of how much the properties are put at. Then if you look on page.
This document's very difficult to read. The court can't really see anything. It's so blurry. So can you tell me specifically what you want me to look at?
Look on page 58.
I'm on 58. There's a lot on here. It's extraordinarily blurry. So tell me
If you look
where.
at the top,
The top?
right where it says sell price. These are the comparable cell number 1, comparable cell number 2, and comparable cell number
Okay. All right.
You'll see in there that the sell price 209, 500, 209, and then 185. Those are houses that are comparable to the ones that our house was. And ours is a 4-bedroom for pool. So.
Okay.
And then let's go to page 62 was the order that was put in place by opposing counsel the day after Mr. McDonald was thrown in jail. This order was needed by the refinance company in order to complete the refi. This was put in, I believe, orchestrated, they conspired to get me thrown in jail and then to sell the house.
Is this a question?
No, so is this? Are you aware of the order that was put
So if you have a pool in our area where I live, that drives the price of the house down. It's not an add-on.
in place on page 62? Day after thrown in jail.
I'm really having trouble reading it.
Just yes.
Are we
Yeah,
talking
well,
about
just
the order?
again, for the record, this document is 2 pages of an order purportedly from this court, but it's squished onto 1 page. So it's very blurry, the quality's bad, and it is difficult to read. But continue.
Was it order 113?
Nobody wants pools here in Lancaster, in this whole general area, because it's mostly too cold for pools, and there's so much maintenance involved, and you can only use it for a couple days out of the year.
13 of 2017. If you look on exhibits, on page 65, there's the dumpster full of the kids' stuff. A full dumpster. This is a huge one of all the defendant, his kids.
Is this a question?
Did you orchestrate throwing away the property of the children and of the defendant?
I was given permission by the court to allow your brother to come into the house and remove any of the items that he wanted. He had 3 days to do that. He took everything that he wanted, and the rest they left for us to do whatever with.
So on 113, when you broke in the day after, or the day of, or the day after, did not 2 weeks later, then you got exclusive possession. Did you have orders saying you could go into that property that you haven't been for 2
I
years?
never entered the property without permission from this court.
So you're saying that it wasn't broken into and you didn't take the...
If it was broken into, I had no knowledge of that.
So you said you did go into property and then
No, I never. I said my parents handled everything with the property. I did not say that I went into the
You
property.
said you went in with counsel, right?
My attorney and my parents were present when they orchestrated everything. I told you it was traumatizing for me to be in the house, and I could not go to the house.
Okay, and then 2 weeks later there was an order for exclusive possession.
2 weeks later from what?
While I was in jail.
I don't remember the exact date. I know shortly after you were in jail, yes, there was an order for exclusive possession, and at that time, my attorney, my parents handled everything with your family so that you could get your stuff out. And they gave us permission and said everything else that's been left in this house is trash. So
granted
then I
by-
was forced to purchase something and hire a clean out company to remove what your family said was trash.
So you gave them 8 hours and then changed the lock, so they weren't able to get the rest of the properties.
That's not true.
But
That's not true. No, my family gave your brother literally from like the entire weekend, from Friday to Sunday at like 8 p.m. And this was the clean out process wasn't done until that time, because we wanted to make sure that whatever your family wanted to keep, they kept, and everything else they told us was trash. And because the house had to be sold, it had to be cleaned out, and it had to be ready to be sold. The condition of the house was extremely bad. The carpets were torn up. The pool was chipping. It was a mess. It was green. There was broken furniture everywhere. It was disgusting. And
2 weeks
my realtor had to take that into account when he listed the house. We were getting extremely low offers.
I love living
for
in
cash.
Pennsylvania. I love it.
And it would not be to my benefit to sell this house any lower, because I would get more money out of it if we sold the house at a higher price.
Are you aware that the order said to list it at market value?
We did list it at market value
65.
based on the comps that were around the area at that time.
Did you ever have an appraisal done?
I think we were using your appraisal, the one that was off of $160,000. He initially listed the house at $189,900. We were not getting any reasonable offers. The court had said for every it was like for every
We listed at market value then lowered.
right based on that. So like as the
Wasn't
offers
followed.
came in, there were no offers that were anywhere near that. We lowered the price to $165. Your appraisal had said $160, so it sold for $165.
Okay, let's go on. We'll hurry this up. The Exhibit V on page 66. This is a list of things
Yet,
to make
Brad,
the defendant
yet.
to paint him in an unfavorable light, saying swords and nunchucks and rounds of ammo. But you didn't list any of the valuable property. I think the gold, the silver, the different things. Well, there were some silver coins, I believe, but not the many that was in there. And there was only, it says that there was $861 in cash at the bottom. There was over $4,300 that wasn't listed. But it's to further poison the well in this court and to paint the defendant in an unfavorable light instead of listing all the
Fair
property.
question, Mr. McDonald.
Are you aware of all these items that were taken out of the house?
Like I said, my parents handled all of this, and they were concerned about ammunition and so on. I can barely read this document, but I'm aware that my attorney made a ledger of the things that my parents gave to him, which included weapons, which is concerning because you were ordered to turn over weapons, and there was a gun in the house that was found, and lots of rounds of ammunition. You had even had your grandpa like write a letter saying that you had turned in your guns, but there were still guns in the house. So, I mean, yeah, that was concerning.
Was my brother not living there?
I'm sorry?
You were aware that my brother was living in the house, correct?
Your brother was not living in the
Living
house.
there after.
No, that's not what happened. Which is why when he took me to court, the judge quashed it because he was never living in the house. In fact, there's a jail recorded phone conversation between you and him where you conspire to tell him to go live in the house so that
not see
I
Alex's
can't
property
take
there?
over. Alex had no property in the house as far
Army
as I'm
bags?
aware. The police were called, and the police basically told him that he had no right to be in the house, which is why when Alex took me to municipal court for allegedly kicking him out of the house, the judge quashed that because he never lived in the house.
How do you know what was going on at that house? You haven't been there for 2 years.
From what I understand, from what my parents said, he was not living in the house. There was not, and besides that, like I've heard the jail recorded phone conversation where you conspired to send a friend of yours from jail to the house while the house is being cleaned out, and produced a fake document stating that he was renting from you, and basically that was your plan to get someone to squat in the house so that I could not take exclusive
Did
possession.
Alex not live in the garage with us when we were married? Or right
I'm
before?
sorry?
Did Alex live in our
Alex
garage?
lived in the garage of your
105.
mother's house when we first moved into your mother's
On
house.
Watkins.
Alex never lived with us in our house. In our house that we owned together. The house your mother owned that we lived in when we first got married, yes, Alex did live in the
Didn't stay
converted garage.
sometimes, but.
No, Alex never stayed at our house.
All right, let's go on here. These are the orders. So in regards to
He might believe what he's saying is
do
true.
you think it's in the best interest of the children to Michael to be able to see his children? I mean, to see our
That's
children.
been answered, Your Honor.
Counsel, sir, you've asked and
Yes.
answered that question quite a few times today.
And I'll do this in my closing statement. Then. Can I ask Dan Dixon come on the stand, please?
Hold on. Are you done with your examination of the plaintiff?
I believe so. Unless there's other. Oh, one more thing I would like to ask the plaintiff is
What's your address and
going
phone
on in the
number?
future. What would you propose would be best for our children?
You've asked and answered, Mr. McDonald. You've asked that at least 3 times today.
Okay, so, and there was questions on saying that she never saw any counseling or mental evals and stuff. So I wanted to just point that out to the plaintiff to see that there has been progress. There has been things that show that's in the best interest of the children to see their father, and that he has taken any and all steps to show
Not a
plaintiff and his
question.
court that he's remediated himself, that he has gone well beyond the scope of the court in regards to showing custody and what's best in the NRS 125 C.0035. And I want to go say
So
that.
is there a question?
So I would like to ask you, have you seen those documents, Exhibit A, B, C, D? Do you think that that's sufficient?
Can you give me the page numbers? Because I don't have tabs in this one.
It's page number 5, 6, 7, 8, 9, 10, 11, 12.
Okay, so page 5.
And just real quick, Your Honor, just objection as to, Candace is not an expert as to what is a
You know,
domestic violence.
Counsel, I made, and well, I'll allow her to review them, but counsel, you know, I'm real concerned about this Exhibit C that appears to be character, counseling, coaching, and consulting signed by Nancy Sargent Hunterton, MALMFT, Nevada license 0988. It really appears to me, counsel, that this last sentence of the first paragraph that says, I do not believe Mr. McDonald is a harm to his children or himself.
But she did.
Hold on. Is in a different font. That the slant of that wording is on a different slant than the rest of that paragraph. It slants up where the paragraph slants down. It's in a smaller font. The language used seems inappropriate and not language that would be used by someone with a master's degree. I'm concerned about the authenticity of this letter. Counsel, Mr. McDonald, I'm going to caution you right now. If it comes to my attention that you are trying to perpetrate a fraud on this court, and you have given me and tried to admit an exhibit that you have falsified, the court will not turn a blind eye. Do you understand?
Yes, Judge.
Have you reviewed all of those items?
I just reviewed
Does that change your mind?
7, 6, and 5. It does not change my mind. You were ordered to take 52 domestic violence classes. This one says that you completed 15, which I confirmed with my domestic violence advocate last week that there have only been 15 recorded with them. That you still have yet, and that you've still yet to complete the other, the rest of the remainder of those classes. Page 6 is a book, Alternatives to Domestic Violence, a homework manual for
Safeness.
battering. It doesn't say it's from Safe Nest. I'm not convinced that you attended those classes just because you have a book. Page 7, which is the counselor's letter, I also have major concerns about this. I myself was in therapy, and my therapist wrote a letter for me. It was 2 pages. She also has a master's degree. And I'm also concerned about the font as well. So I don't even know that that's authentic. And really, if you strike that last sentence, Michael McDonald has seen me for individual therapy to address his issues related to divorce, his personal well-being, and develop insight related to his separation from his ex-wife, especially his children. We have met regularly since his release from the City of Las Vegas Detention Center in June 2017. Please contact me if further information would be helpful. That does not convince me. And this is also dated August 31st, 2017. It doesn't say anything about, you recognizing your issues or owning, or it just says that you're there to address your issues regarding divorce and your children. So that's not convincing to me that there's been a change. Page 8, which is the mental evaluation from Greg Harder, which goes all the way to page 12. I haven't read yet, so
You just look at the very last page. That shows the diagnosis.
I'd like to read it all, if you don't mind.
Can we not use court time for that, Judge?
You asked her to look at it, so she has to look at it, Mr. McDonald.
Well, I would direct you to page 12, and that's the last.
So you don't want her to review it?
We could review it.
I mean, this.
I would like her to review it.
Well,
Judge.
just so that you know, this is why exhibits are ordered to be exchanged, right? So there's mandatory discovery. Anything you're going to rely upon, you got to give it to counsel. No, you didn't. Had you done that, she would have had an opportunity to review it. If you had given me your exhibits and your pretrial memo on the date ordered, she would have again had another opportunity to review it and been prepared for today. But we'll allow her to review it, and then we'll get back at it.
I would like to address that the last statement is, or at the DSM, this is adjustment disorder due to divorce proceedings and marital issue. Judge, this is something that is completely emotional. I mean,
Is this a question?
Well, I'm just addressing it to Ken. How do you feel about this report? Does it qualify that there has been sufficient?
I really would like to read it before I give you my answer, because I know your character and I know you are really good at manipulating people, and I wouldn't be surprised if you met with someone 2 days
Fozzie is
before
the
the hearing
best.
and
Seriously.
told them that you were fine, even though they don't have the whole idea of what's happening. So if you don't mind, I would like to review it for just a moment. I'm a pretty fast reader.
Hey, Fletcher. Want to come play at my bar?
I mean, I have an issue with the letter. On the first page, which is page 8, this first paragraph, which says reason for referral, is then again repeated on page 9. Whomever wrote this basically copied and pasted exactly what's on page 8 on page 9. I'm not
Terry.
certain that somebody that is a psychologist would do that. And it's concerning before I even finish, which is, I explained to him that he was being evaluated to determine if he had any mental health problems, but I do not do child custody evaluation and cannot make recommendations to the court about custody of his children. I explained to him that the results of this evaluation, which potentially includes everything he told me during the evaluation and any records or test data he provided me, would be released to his attorney and himself. However, it could be potentially released to the opposing attorneys as well. He understood the purpose of the evaluation and the limits of his confidentiality and orally consented to participate. On page 8, Mr. McDonald referred himself for a psychological evaluation. He stated that he is participating in a child custody case, requested an evaluation to prove that to the court that he does not have any significant mental health
Thank you
issues,
so much,
that he is a
SB.
good
Thank
parent,
you,
and he
thank
should
you,
be
thank you.
able to have joint custody of his children. I explained to him that I do not perform child custody evaluations. However, I would be willing to evaluate his mental health to determine if he had any mental health issues. Since this evaluation was requested only 2 days before his court appearance, the scope of the evaluation was limited to an interview, a review of records provided by Mr. McDonald, a psychological test, and a personality assessment inventory as a result of this evaluation are described below. So basically, like, this psychologist only had a very limited scope. I feel like, no, I think if your psychologist knew the level of what I've had to deal with, they would make a different evaluation.
Ever been psychologically evaluated?
I've been to counseling, but I've never been diagnosed with anything.
Never.
Nope, never.
And you saw our counselor's wife, is that correct? Our marriage counselor's wife.
The counselor, the male counselor, did our couples therapy, and I saw his wife, yes, individually.
Do you still see a counselor
I do see her occasionally.
occasionally?
Yes, occasionally, to deal with
Are
this stress.
children in counseling, or they're
Malia was in counseling for a brief period after.
for what? Or what cause?
After you took her and that domestic violence incident, she was having violent nightmares about you taking her. And I took her to a very well-known child counselor that deals with children that are really young. And I wanted also to make sure 100% that there had been no sexual abuse at all. So I presented that to her as well. She determined that there had been no sexual abuse and what we were dealing with was trauma. And she gave me a lot of
Is Leah doing
great
good?
things to help her, you know, like things like telling her she's okay, she's safe, making sure she kind of has this, she does like a sensory thing where she smells my hair a lot for comfort. So one of the things that we tried with her is like a shirt of mine that smells like me. She'll sleep with that because it brings her a lot of comfort. She also suggested essential oils are super helpful. Making sure that bedtime routine is consistent. So
Is she doing good now? Is she okay?
I would say she's doing much better. She still has trigger moments where she's afraid that you're going to take her. And
Oh man, if he thinks deodorant and candles are very unhealthy, he's gonna flip. But once the essential oils comments hits his brain, he's gonna flip.
she still has nightmares.
Talking now?
She is talking. She's been in.
I haven't seen my own daughter in over.
She was in speech therapy because she had a speech delay, and she's now 85% intelligible, which is amazing. She's been in speech therapy since.
You don't think that
last summer.
not seeing her father has anything to do with that?
I'm sure. I think it more has to do with the trauma that she suffered when the domestic violence incident took place, because I know that she was even potty trained at that time, and then she went back to wetting the bed a lot and having nightmares.
Somebody left a comment, and I can't remember the name off the top of my head. It was awesome. He said, remember yesterday when he was reading that list of statistics of children who, don't have a father, or how bad they're going to jail, they're blah, blah, they don't finish school, they don't have any money, blah, blah, blah. The comment I got was like, Candace should have asked him what the statistics are for someone who had a better father than him. Oh man, he would have flipped.
And her talking seemed to kind of delay after that point. So I do think some of her delays had to do with that traumatic incident.
Did I teach her did I potty train her and teach her how to walk?
Malia was not walking when we split up. She took her first steps in the condo that I lived in far after we were split up.
Took steps in the
As for potty training, I don't know. I don't know. I mean, we were at that time
Me and Mason,
changing her back and forth. I think we were both doing potty training.
she was potty trained for daycare and also was.
But I think that
walking.
that incident was traumatizing to her. So I did seek therapy for her, but she's no longer in therapy. Her therapist thought she was having a lot of progress with the stuff that we were trying with her at home, and she felt like even therapy itself was traumatizing. So like every time she came, she felt anxious and upset, and so she just asked me to. She just said that we didn't have to.
Let's
continue
move on
her.
to the appellate brief, and on the pages.
Mr.
16,
McDonald, you have 24 minutes remaining.
Okay, so on page 16, 17, this goes into the procedure, what happened. On page 18, the court erred in denying the defense motion to
We need to hear more about potty training, please.
continue trial. The defendant asked for an attorney and to seek counsel, and he was denied. He was denied due process of law.
Is this a question?
Was
Objection, Your Honor.
was-
Candace has.
Allegedly,
aware
Ed
that the
said
that
that
the domestic
comment.
violence
It was
is on
awesome.
appeal, and that,
Thank you,
that
Fozzie.
it's perpetuated that the pushing never happened. Domestic violence did not occur, and it was now being used as a silver bullet into keeping Mr. McDonald's
probably
children
will.
from him for over a year.
She probably will.
You asked me like 5 questions. Which one do you want me to answer?
Are you aware of the appellate brief and know
I'm aware that your domestic violence charges are on appeal, but from what my domestic violence advocate said, those domestic violence charges stand until the courts make a decision about
was there
that.
any evidence of the pushing?
There was evidence, yes, presented, which is why you were convicted. There were witnesses, and there was your own testimony, and then there was the phone calls that were recorded.
And the phone calls were recorded illegally.
No, as soon as you called me, I picked up the phone. I said, this phone call is being recorded. You continued to talk, therefore.
I do not consent to phone recordings, yet it was still used, which is a felony charge here in the state of Nevada.
Is that a question?
Are you aware of that?
Am I aware of what?
That phone recording is a felony charge.
If you do not tell the caller that you are recording the call, yes, I'm aware of that.
Consent.
Which is why I said.
Are you aware of the errors in the court and what happened?
I'm sorry?
Are you aware of the errors in the court that's on the?
I'm not aware of any errors.
So the violation of protective order, did you use that to bait Mr. McDonald into the parents' house?
Which violation of the protective order? There were 3.
To go to the parents' house, say to pick up the children, say you're not there.
No, I did not bait you.
And there is
She is a master at that, though.
On page 44 that says, they will meet you in the church parking lot. I've already left my parents. If you are not there, I'll be there to pick them up, and I'll be back.
Objection, Your Honor. We've been over this ad nauseum at this point.
No,
It is asked and answered. You got 22 minutes. If you want to spend the 22 minutes asking her questions and you won't have time to tell me or for you to testify, this is your motion. You have the burden of proof. You have an opportunity to tell me what's changed. I haven't heard that yet. You spent 2 hours and 40 minutes asking her questions.
I'll go ahead and rest with the defendant. I asked that Daniel Dixon approach the stand, please. Thank you.
Hold on. At this point in time, generally, we would allow plaintiff to cross-examine the witness. Do you want to call her in your case in chief,
I
counsel?
will reserve my right to call her, Your Honor.
All right, thank you. You can have a seat. Mr. McDonald, who do you want to call?
Daniel Dixon, the stepfather that was supposedly at the property and also can attest to what happened on the day of 11/11, which is in regards to custody and domestic violence, which has been perpetuated upon this court this far.
Okay, all right, sir. Come on up to the witness stand. Remain standing, and then you can raise your right hand to be sworn. I think you've been here before with us.
Do you solemnly swear the testimony you're about to make in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir, state your name and spell it for the record.
Sure. My name is Daniel Dixon. It's Daniel Dixon.
And how do you know the plaintiff?
He was my son-in-law.
The defendant was your
Oh,
son-in-law.
I'm sorry. She's my stepdaughter.
All right, go ahead, Mr. McDonald.
So, did you see Mr. McDonald push Candace?
Yes, I did.
How so?
Objection, foundation, Your Honor.
All right, so tell us, remember what foundation
So on the
is.
day of 11/11 of 2016, when Candace said to pick up the children at her parents' house, you were in the garage, correct, with the children?
Why in God's name would he bring this witness to this stand and ask this question? This actually does have some bearing on child custody if he proves that he has abused her. What the heck?
I believe I was on
Towards the back door, or
no, not first. I met you halfway down the street trying to get you to go back to the parking lot because you were yelling and screaming at Joe, calling and cussing, and I was trying to get you to go back, told you I'd bring the kids. You kept on coming in.
did Mr. McDonald make any threats?
Pardon me?
There was no threats made, correct?
By you? Oh, yeah. You were going to kill Joe.
Did you ever hear him say that?
Did I hear who said that?
Mr. McDonald, did he ever say that I'm going to kill somebody? Did he ever say that? Did you hear that?
He was. You were yelling and screaming.
So you don't know
cussing,
exactly what was said.
You were cussing at Joe. You're telling him that he blessed your daughter, and we tried to get you to go back. We kind of pushed into the garage. Candace was standing off the side. You went to go past Candace. You pushed her off the side. You reached over for Mason's arm. Mason pulled back. You grabbed my wife's arm, tried to pull her back to reach on the Mason.
How did Mr. McDonald push Candace if he had did he not have his daughter in his arm and the backpack in the other arm? How did the pushing happen?
I don't remember exactly how you pushed in there, but I remember you pushing with your one hand past her to get past her.
Or how,
And I was right there on the phone, and we have it all on 911 tape. The whole situation that happened.
So the pushing is the cause of the domestic
I went in the
violence.
garage to call the police.
Was there any bruises or was Candace harmed in any way?
Physically bruised? No, I don't believe so.
Okay, and did you see Mr. McDonald leave with his daughter after you asked him to leave and you called the cops? Did he not leave?
Did you what now?
Did Mr. McDonald leave the house when you asked him to leave your property?
After I asked him a number of times, I asked him to get out of my garage. But I had to ask him over and over. We were yelling and screaming. At that point, you were holding Malia, and we were yelling and screaming at each other. I was still on the phone with 911.
Asking to get Mason, correct, towards towards the back.
Yeah, we couldn't get inside the house because we told Joe to go inside and lock the doors. So we pushed into a bad position because we were trying to get back and get the kids and Candace into the house, but the door was locked. So I was on the phone in the garage trying to get the cops there. They were pounding on the door, and then Mike came in there, pushed Candace off the side. He reached in for Mason, and Mason was terrified. He was hiding on the door, and he kept on trying to reach it, and then my wife was saying, no, get back. I was saying, get back. Finally, the door opened. They got inside. They closed the door, then locked it on me.
Did Mr. McDonald, did he leave the situation afterwards and then ask you to bring Mason out after we had a phone conversation?
Yeah, I asked you to get out. I closed the garage door. At that point,
and you said
I
to
was
come back
finished.
to the property, and you're waiting for the cops to come to put me in jail. You said to come back and get Mason. Do you recall that conversation that we had?
I recall the police showing up and all of us giving our reports to the police. You kept on texting me, telling me to bring Mason down to your grandparents.
He's
And-
so stupid.
Did you guys ever cuss at Mr. McDonald during custody exchanges, or were you perturbed that he was late a few times, within 15 minutes late, 5 to 15 minutes?
Who was late?
Mr. McDonald.
You were late?
Yes.
2 hours? 2 hours, not 15 minutes, Mike. 2 hours is a long time to be late.
So there was one occurrence of a 2-hour wait when Mr. McDonald.
Let's lay some
Did Mr.
foundation.
McDonald not let Candace know that there was
When?
dinner? During October of November 2016. He let Candace know that he had the children that he was running late he had a dinner with his grandpa that was really important. That he just had surgery, and he asked for an extra time, which she said that's fine, but you need to bring him by 8 o'clock. Was that not perpetuated? Were you aware of that?
I don't remember that situation. I'm sorry. There's so many
Well,
situations
what
that were.
Do you think Mr. McDonald's a good father?
You know, I'm glad you asked me that, because here's my honest feeling is that I think you're right. I think every child should have a mother and a father. I honestly believe that. And I was a good father to my kids, and I always thought that I would always be supportive of their mother and have a good co-parenting type of environment. You? No, they're better without you.
You had a divorce, correct? You had a contentious divorce with your ex, and
I did.
your kids had issues
did.
based on that, correct?
I did.
Did you know the effects of not having a father? Were you alienated at one time?
Well, if
Read
the
'em,
effects
read 'em
are
out.
not having a father versus having you as a father, I take not having a father, because you talk to a 5-year-old like they're 21. You tell them things that they shouldn't even
Have you
know.
ever seen him have those conversations with his child?
I read a letter that you sent them.
Just hearsay.
I read a letter that you sent them from jail. That was so inappropriate. I couldn't believe you were writing to your children.
Have you ever been in jail, Mr. Dixon?
Yes, I was. I got a DUI one time.
And did we not work at the city together?
We didn't work together.
We worked in the same. Well,
Worked at the city.
yeah. And didn't we do all kinds of activities together, dinners, and I would say, a good relationship and help with different things. Is that correct? I mean, you would see Mr. McDonald play with his children and see the love that he had for them, correct?
Yeah, I seen him play with his children. I mean, he was more of a friend than a father.
And
my opinion.
do you believe that fathers should have unalienable God-given rights to their children? There
No.
should be a high set standard of what they can do to lose
No,
their
I think being
children?
a father is something that you
Okay.
you don't deserve automatically. I think you earn it.
And do you know any perfect parents out there, Mr. Dixon?
No, everybody has their faults.
And have you coached Mason's baseball team recently? Have you been helping him to get that scholarship that you said you'd help him with?
I haven't coached his baseball team, no.
Please do. Thank you. I'd like to call Joe on the stand, Judge.
You got 14 minutes. Counsel,
Thank
would
you.
you like an opportunity to cross-examine this witness, or would you like to call him in your case?
I'll call him in my case. I'll reserve the right to call him in my
Thank you,
case.
sir. And what's Joe's last name?
Ruiz.
Mr. Ruiz, can you come on up
Your
to...
Honor, Mr. Ruiz hasn't been listed by either defendant or myself as a witness in this case.
Mr. McDonald, what's your response?
Judge, he can attest to
No,
the.
no. So he wasn't listed as a witness by either party.
I believe, I don't know if I put that on my pretrial memo, as there was a lot of scrambling, but I did have list, it said any rebuttal witnesses, so that him being here constitute a rebuttal witness in my.
All right, I'll allow it, Mr. Ruiz.
So from now on, you could just put any rebuttal witnesses, and then you don't have to give a list of who you're going to call.
Come on up to the witness stand. Remain standing. Raise your right hand to be sworn. Mr. McDonald, you're going to have a seat.
Yes, Judge, thank you. My
And you're
hands
not
are-
going to get up during these questions. You understand me?
Yes, Judge.
Sir, raise your right hand to be sworn.
Do you solemnly swear the testimony you're about to make in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I called you Mr. Ruiz 2 times, but I'm going to guess it's Mr. Ruiz.
Yes.
All right. Mr. Ruiz, will you state and spell your name for the record?
First name is Joseph, Joseph. Last name is Ruiz, Ruiz. No middle initial.
Thank you. Go ahead, Mr. McDonald. You have 13 minutes.
Were you married to one of Candace's friends, Nicole Spinlove?
Absolutely.
Did you ever, was there ever was ever stated that you raped
Objection, hearsay, Your Honor.
Miss Miss Spinlove?
I'm going to allow
Were
it.
you ever the cops ever called out?
No, never.
Were you aware of that she would tell friends such as Candace of those situations?
Objection, hearsay.
I'm going to allow it.
Did she,
If she was sexually molested or assaulted by me in any way, she still married me. There was never that case never happened. There's no record of that. And once again, that was he say, she said.
did you get a divorce during the time that me and Candace were divorcing?
Pretty close, yes.
Did your ex have any sexual contact with my ex?
Not that I know of.
So were you aware that your
What?
ex
What did
is your
you
ex
just say?
a lesbian now?
Mr. McDonald,
No comment.
hold on.
This
Mr.
is-
Hold on. No, how is this relevant?
It's relevant.
I mean, I don't want to trash talk people.
It's relevant.
Bring
Keep it
people
going.
in.
You're right,
Being
Judge.
a lesbian
I'll-
is wonderful. This court doesn't look down on that.
I
Those are
follow-
people's choices, all right? And I'm not going to let you. You can spend about 3 hours talking bad about everybody
I
else,
agree,
but
Judge. I'll
she's
do-
not a party, and that's very distasteful.
Only
all right?
relevant stuff. I apologize.
How is that? It's just, you're trying to insinuate something bad to the court, and let me tell you, the court doesn't think it's bad. The court's all for it.
All right, Judge. So, Mr. Rose, did you ever touch Malia in any appropriate ways?
Absolutely not.
Are you aware that Malia stated to
Good
certain
job,
relatives
Judge.
of my family that Joe touched her pee-pee?
I was not there, so I couldn't say.
You were not there. Have you ever watched The Children Alone?
No,
Never.
never.
Have you
not
ever?
allowed.
Huh?
I'm not allowed.
Do you ever smoke marijuana or do drugs?
No,
Never.
never.
And you've never smoked marijuana or recreation drugs with the plaintiff?
No.
No. Did you take Mason to event alone? You ever take him alone to different places?
I took him to Aviation Nation.
Yeah.
We went together.
You have fun?
Hello, my beautiful son. Welcome.
Absolutely. You could talk about the pictures because that's how you know.
Do you play with Mason?
Yeah, when he wants.
Does he ever play out in the street alone or
No.
places? He's always watched by somebody?
Absolutely.
Do you help coach his team or bring him to any events like baseball or soccer?
No, I've been to his games. I've helped him
Is he good?
catch. For his age, absolutely. You should be there.
I wish I was. Um, so, do the kids ever call you daddy?
Savage.
Never?
No. They just call me Joe.
Do you take them to school?
Yes, I take Mason to school every morning
Take them to school every morning. At what time?
when school starts.
Are you ever alone at the house with the children?
No, I'm not allowed.
Who brings the children or Malia to daycare?
Our mother.
Have you noticed any self-esteem issues or any issues with Mason or Malia, or do they ever say anything about their dad or ask you questions about him?
Not really.
Are they happy children?
Absolutely.
Have you ever seen any breakdowns or mental breakdowns by the plaintiff?
No.
No? Has the plaintiff ever hit you or hurt you or yelled at you?
No.
Never.
We know how to communicate.
Wow. Okay. Is there any means of... Were you in the house on the day of 11/11 of 2000? 1/12 or 1/13 in January of 2017.
Objection lacks foundation as to what house.
Which house?
The house
is
on
it?
5813 Maynard.
No, not that.
You never went there? Never took property out of the house?
No.
Were you aware that there was property that was being taken, or did you ever see a safe?
That was none of my business.
Okay. During that time of separation, when did you guys first get together?
Mr. McDonald, how is this relevant?
This show, during the time of those 90 days that Mr. McDonald didn't see his children, that's when the supposed rectal prolapse.
Guys, you want to see something? Hold
To
on.
know what time frame that the relationship occurred.
All right, I'll allow it.
September of 2015.
Has there ever been any girls that say they're uncomfortable around you,
No.
like such as Sharina or her sister? Or,
You seen your ex-wife? She's not afraid of me whatsoever.
do you still have a relationship with your ex-wife?
No.
No.
That's Anthony Estrada. Yeah. That's
Do
him
you
working.
love Mason and Malia?
Absolutely.
Do you help foster a relationship with them and their father?
I wish you could.
Do you talk good about them? Do you say anything in regards to that?
Excuse me, say that one more time.
Do you say good things about their father or talk about them at all?
I don't say anything bad about their father.
Or good co-parenting, no? Do you ever ask the plaintiff to, what's the deal or what for?
Well, I'm fully aware of the deal. I mean, you're not supposed to be 100 yards from me, too, so I know
Are
exactly.
you afraid of Mr. McDonald?
You're unpredictable.
Have
That's
I,
what I'm afraid of.
What have I done, or what has Mr. McDonald done that's unpredictable?
Coming across the street, threatening my life.
So did
In
you,
November of 2000.
were you aware that there was those charges that was sent to Candace? Did she show that to you? And what would your mental
I
state
was
be?
there in court when that happened, so yeah. Because I was subpoenaed, so I had to be there.
What would your mental state be if you found out some stranger with that kind of record was watching your children?
I don't have a record, so I couldn't say.
Let's say if you, just somebody else, if you found that out that somebody.
Objection incomplete hypothetical, Your Honor.
Okay, so we're not going to do the what if.
All right, so do you plan on being in the children's lives and being a stepdad to them?
I am marrying Candace McDonald, so yes, I do plan on being in this house.
Are you aware that she said she would never marry you before, or she would never be in a relationship with you prior, and she used to talk?
As you know, things change. She married you.
And do we not hang out one or two times before? Baseball game or something?
Yeah, one or two times.
Okay, that's about all the questions I have, Judge. Thank you.
Mr. Counsel.
No questions,
All right,
Your Honor.
sir, you can have a seat again. Mr. McDonald, you have 5 minutes. Would you like to testify?
So when can I do a closing statement? Is that after the testimony?
Okay, so as I indicated previously, After each of you is allowed 3 hours to present your case, you may give me closing arguments. Closing arguments is not testimony, but that will be at the conclusion of today's proceedings.
So can you explain, the testimony would be in regards to what's on the exhibit list that he gets to depose? Is that what happened?
No, just whatever you want to tell me. This is your motion. You have the burden. You have to tell me things.
So yeah, I would like to.
Okay, so you need to raise your right hand.
Do you solemnly swear the testimony you're about to make in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Hold on. Is that a yes, Mr. McDonald?
Yes, Judge.
You have 5 minutes.
Okay, I will try to make this brief. So today I'm here to say I consist of a sworn statement to the court on matters in regards to my case to get in regards with custody and child support assets.
Sierra.
I would like to bring
Hi, Fuzzy
our case in
Dog.
chief to show that it is in the best interest of the children that their father be in their lives. I can have different case laws such as Rico versus Rodriguez, Rivero versus Rivero, and Drager versus Drager, where it ruled that the trial court erred in changing custody without specific notice of the requested change. That occurred during Hardcastle's pendency after she filled in. Trucks versus Trucks says that if it is shown that it is in the best interest of the children requires the modification or termination of a joint custody, any order of joint custody may be modified or terminated by the court upon petition of one or other parents in the court's motion. It also states that the
Linus,
moving
are you
party in the
working?
corpus must show that circumstances have been changed, that somebody substantially changed since the most recent order. Since the most recent order, there has been zero contact for 450 days. It is not in the best interest of the children not to see their father and have a meaningful relationship. It's also not in the best interest of the children to not be able to be in their lives and be at their coaching events. It's not. It's also. Here, let's see here. It also proves that there has been a change of circumstances. I've been put in jail because of orders I was confused about. And there's been so emotional, Judge. There's so many things that have happened. I just want to have joint physical custody of my kids. That's the whole thing of this, the pendency of this case. There's been a complete poisoning of the well by attorney and plaintiff, and they completely make up complete lies that were never rebutted and never proved against. And I've had very ineffective counsel, especially one ended up taking his own life, and he was a great guy. I felt terrible for. I even had his dog for. This case. There should be a tier of fact of what is in this case and all of the things that have happened and the consideration for that. And when there was orders for every weekend visitation, things were going well. Things started happening. Then all of a sudden, when she finds out that when the plaintiff finds out there's a girlfriend, that's when everything blows up and it becomes a vindictiveness. And regards to custody, as she would not agree to joint custody when we sat with our stepdads. We agreed to everything but custody. She wouldn't agree to 40% of the time. She knows I'm a good father. I take good care of my children. I'm very involved in their lives. And I know the effects of not having a father. And I know more than anything that I have a great duty and responsibility to steward those lives of my children. And I ask this court that I be able to do that. And that we see the full pendency of this case and show that the counsel's lies and fraud on the court is complete lies. I've done so many things. I've learned so much, Judge. I've learned so much about a legal system, going to jail, going to classes, going to divorce cases, counseling, groups. I've done more than you'll ever know, Judge.
Yes or no?
I've done and remediated
That's
this.
kind of the problem. You need to tell me what you've done, all right? That's the reason why we're here. That's for the motion. So don't say, I've done more than you'll ever know, Judge, because you just had 3 hours to tell me what you've
I
done.
thought that was just test for witnesses. I apologize, but here's a couple of things I've done. So I've been going to counseling regularly. I've been going to my pastor's meetings. I've been going to divorce care, to the cases for Celebrate Recovery for life issues. I've helped so many people that are going
What
through
are life issues?
life issues such as divorce or alcohol, whatever. All kinds of groups there that they have.
Okay.
And I help
And
foster men's
when did you
groups.
start? How often do you go?
So I used
And
to,
how long are the classes?
so I used to go to these classes and to men's groups.
Okay, no, let's just
during the
start.
marriage.
I need you to tell me everything that you've done since the last order. Remember, we talked about it.
Since the-
August 16th, 2016. What have you done since
Since the last
that
order,
date?
Judge, I've been going regularly to celebrate recovery on
What
Mondays.
does regularly mean?
Mondays, almost every Monday.
Almost every Monday
At the crossing, and Jeff
at
Moore.
the crossing
Jeff Moore, the
since
pastor.
August 2016.
So let it
I've
be
also done
written, so
divorce
let it
care,
be
which has
done.
been very enlightening.
What is divorce care?
It's a program that was made by Dave Ramsey and other people that actually goes and teaches you how to overcome a divorce, how to be a good parent and co-parent.
Where is that class at?
That class is also at the crossing on Monday.
How often have you attended that
On
class?
Wednesday nights regularly, Judge.
Since regularly
Since the last order of this court.
August 16th, 2016. So you're at the crossing on Monday night?
On
You're at
Wednesday
the
nights
crossing
usually.
on Wednesday
and Sundays
night?
usually.
Okay. And then what else have you done?
So, Judge, I've also gone to counseling with Nancy Hunterton. I've done multiple men's groups.
How long have you seen Nancy Hunterton?
Since after getting out of divorce. I mean the jail, Judge.
Okay.
Yeah.
And you've seen her weekly since you got out of jail?
It's usually every other week, Judge. She's usually busy. And
Every
scheduled.
other week since you got out of jail.
It varies, but yes, Judge, regularly since we've been out of jail. I've also taken the eval. I've done everything.
When did you do the eval?
That was previously to the trial. So
It was before the trial.
before the yes.
So when Judge Hardcastle ordered you to have a psychological evaluation
That was done in jail,
November 2016,
Obviously, yes.
where is that evaluation and who did it?
So that was in jail with Dr. Green, Judge.
Okay.
So that was.
So where is that evaluation?
I have not been privy to that.
So you're telling me that the municipal city jail just went ahead and gave you a full bore evaluation?
They did give me an evaluation in jail, Judge. That was that per requirement. Yes.
Well, per the requirement, as in they were concerned about you in the first few hours and they gave you an evaluation?
No, Judge. They came in on request of Judge Almasi. So
Judge Almasi requested you to be evaluated?
I believe so. Yes.
Okay, and how long did that person, Dr. Green, spend with you?
For a couple hours, and that's all you have in jail is time. So, let's see.
Where is that evaluation?
I have not seen it, Judge. Probably with the municipal records, Judge.
Okay, why do you think it was an evaluation?
I was told that it was an evaluation, so that's what.
Okay.
The court has the authority to award joint physical custody. I want to let the court know that I want the court to know that I'm a new man, a new creation. I was born again through the fire and adversity of this court and through perilous unfortunate circumstances that have happened. I take responsibility for being emotional and for doing some of the emotionally driven things that I did, but I've never tried.
What?
What's that?
You just said you take,
Take responsibility
yeah, so for what? For what do you take
for
responsibility?
trying to get back with the defendant after the court said not to the court said that you can get a divorce for any reason I believe that our marriage was brought on by God and that it could be redeemed, but Judge, I've moved on. I have a beautiful girlfriend now. I don't have any regards to that. I just want to be a good co-parent. I've also done things such as I've learned I followed all the court orders since the last orders and learned so much about the divorce and legal process and the power and importance of it. One day I'll be an attorney, Judge, and I'll know this process a lot more and help many people through this. I also want will do what's best to help many families and especially my own and raise and foster my children's. I've in fact learned and studied so much and it's to help what's best to help the laws out here. I've attended the child support hearings. I've a committee that's redoing child support here. I've actually gone in September of 2017. I was asked to go to D.C. in Washington D.C. and spoke to almost every Congress member in the House and Senate, and I lobbied for equal parenting. And then months later, in November, I went to every committee member. And months later, there's now a bill called H.J. 121, which is a constitutional amendment for equal parenting, and it shall not be infringed. So if passed, so it's still in Congress. I've also met with all kinds of experts and things of what's going on in our society and the devastating effects and the social issues. And I know that it is not in the best interest for the children not to see their father. It's not It's not in the best interest for them to not have meaningful time with their father and to help bring them in the world. It's not best to miss out on holidays and presents. When I try to bring presents to them on Christmas, I asked counsel, how can I bring presents to my children for Christmas? Never got back to me. I went multiple times to try to drop off things and nothing. I would like to. I also say that it's not in best interest to miss out on the father's whole side of his family. The kids had a good relationship with my cousins and uncles and aunts and the grandparents. I have a big family, Judge. I have an Italian family. We love each other. The family is big to us. It's important. I also say
McDonald
it's
is
not best
very
for my little
Italian.
girl to be 2 years old and not be able to see her father. That last time I remember her snuggling with me at daycare when I saw her that day, and not being able to see her.
Snuggling with her at
She's
daycare?
kissing me and saying, Daddy, I love
The
you.
day that you took the wrong kid and then
No,
took
Judge,
her?
I never took the wrong. That's complete hearsay, Judge.
You didn't do that?
No,
Are you
I-
talking about that day, though, that you picked her up off the mat when you weren't
No,
supposed
that
to
was
be
a different
there?
day, Judge. It
A
was
different day. Okay.
It's not in the best interest to not have meaningful trips. I asked multiple times. We go to Duck Creek every summer, and we had a great time. My little niece and nephews, I'm fishing with them, teaching them to fish. I wish my kids were there to make those memories. To deny the children love from their father and from their parents it's child abuse, Judge. Not to be able to make those memories of them fishing and teaching them how to do that. Those are things that have changed my life, and I want that for my children. To not have good co-parents to help raise them, to deny access to them, to deny phone calls and video chats.
Okay, you're 5 minutes over on your time. I'm going to give you
All right, well,
1
Judge-
minute more because you'll be about
I knew it.
7
I
minutes
knew it.
over.
I knew it.
Thank you.
I knew
Thank
she
you,
would
Judge.
give him time.
I don't want them to miss out on their life events and deny the children's right to a parent because you're supposedly she's afraid of me, Judge. I've done nothing. I have done emotional things that have gotten me to this position, but nothing warranting throwing me in jail for 6 months for trying to call my children. I just want to speak with them. Throughout this whole 3 years has been a constantness of alienation, of saying you're not going to see the children, you will do what I want. And Judge, I just want to have equal protection for my children. I want to be there for them. I'm okay. We had an emotionally tumultuous relationship in a lot of ways, but we also did a lot of things. We both love our children. And I know she's a good mom. She does good things for them. And I think if we had orders setting that, we wouldn't have issues. We just avoid each other. We would be good co-parents, so they're talking parents, and go to their games. I'll sit separately and cheer on my son and coach him, and she could do it too. We should do what's in the best interest of them together, and not just keeping them away for spite and greed. So I ask that I've stayed far away since the court order. I've stayed far from her place of employment, from the kids' school, from everything. I've attended various CLE classes in regards to custody and support. I recently got appointed to the Bar Fee Dispute Committee as a lay member. I'm actually running for office, Judge, where I can help go to the state senate, where I actually attended when I was in high school. I attended Boys State and
I would vote for him. I don't care what anybody says. I would vote for him. Dude, I will vote for you if I ever have the chance. I'm voting for you. I don't care.
pass mock legislation up there. And one day I'm going to do what I can to help change these laws. So I believe that my path has been divinely, all through all this, that it has been divinely guided. And I read the book, The Purpose-Driven Life, in jail. And I'm a reformed man, Judge, and I deserve equal access to my children. I will do whatever is in the best interest and be a good co-parent and love my children and love her for being there and for giving me such beautiful children. And I want to maximize my time with the children and be able to see them. And I also say that it's in the best interest to have joint physical and legal custody of the children.
We had a presidential candidate on only this channel before. He ran a landscaping business and he was going through a divorce. It was epic.
And that we can be good co-parents together, and to give me that chance again. And I could also go into a bunch of case law.
Oh,
but
now
I'll wait for that.
you're
Thank
8
you, Judge.
hours over the time that I allotted you.
All right. Thank you for your time.
We're going to take a 5-minute break, and then we're going to come back, and we'll hear the plaintiff's case. All right? Thank you.
All right. We're
Thank you.
I want to be coroner instead.
All right, we're back on the record. Have a seat, counsel. Relative to his objection, the statute in subpart 2 indicates NRS 48125 sub 2 that evidence of a no-low contingent plea or an offer from being admitted both in criminal and civil trials. However, in Taylor v. Thunder, 116 Nevada, 968, 2000, the court indicates in its discussion, here we're not discussing an offer to plead guilty. It seems as though that you're discussing an actual plea of no-low. And Mr. McDonald, are you on your phone?
I was going to look up Thunder. Could you explain that to me, please, Judge?
I just gave you the citation. I'm making the ruling now. I don't want you to be on your phone while we're in court and while you're testifying. So we're not talking about, and Mr. McDonald argues that due to his plea of no-low, that nothing associated with that criminal charge would come in and be admissible in this case. Not the criminal complaint.
Fozzie can't be governor of Texas. He just can't be, because when people like me think of Texas, we think of food, the food that they have down in Texas, and Fozzie hates all food. So it just wouldn't be a good fit. If he would open his mind up and start eating real food, lots of real food, Texas food, then maybe.
Not his conviction, not anything. I believe Mr. McDonald's argument is too broad. The fact that he pled no-low will not be considered by the court. However, evidence of prior bad acts may be admitted prior to the evidence, provided the evidence is relevant and the prior incident is proven by clear and convincing evidence. Even if the trial court determines that the prior bad act evidence is relevant, the evidence is not admissible if its probative value is substantially outweighed by the danger of its unfair prejudice. The determination of the district court is to be given great deference and will not be reversed absent manifest error. Here they're talking about Petrotelli hearings in the criminal context and about bad act evidence. Here, Counsel, you're not trying to show me that Mr. McDonald is a bad guy because of this prior
Kelly
bad act
does
evidence.
have a point.
We haven't had any 404B
Okay, I'm in.
motions. That's not the case. You're requesting this information relative specific instances that are relevant to the best interest findings of this court. Is that correct, Counsel?
That is correct, Your Honor.
Mr. McDonald, do you have any
I do have an objection to that.
go
Judge.
ahead, or just any response at all, not an objection?
Well, there's a response is under NRS 48.025 there's a establishment of character, and when counsel's trying to establish character defamation or defamation of character, there's a certain things that he needs to follow under NRS 48.055 in to means to establish character.
So, Mr. Collinsworth, Counsel, you are not, as I stated, trying to bring this criminal act in as evidence of bad character, but evidence of factual situation that happened between these same parties in a different court. Is that correct?
That's correct.
And certainly Thunder allows that the evidence of a no-low plea is admissible in a subsequent civil proceeding consistent with the terms of 48035, which states evidence will not be admissible if its probative value is substantially outweighed by the danger and unfair prejudice of the confusion of the issues or misleading the jury. Here, this is a bench trial, and I'm not concerned about misleading the jury. The court understands the impact of a no-low plea. He's not talking about a plea 25 years ago, no-low to some DUI or something.
Judge, is there a way I could request a trial by jury in family court?
Would you like to request?
Is there a way to?
We're about 3.5 hours into your evidentiary hearing on your motion to modify. Are you requesting a jury as to this evidentiary hearing as your motion to modify
In regards to what happened,
during the middle of your testimony?
well, I ask you, Judge, if there should be basis for a trial based on if there's circumstances which is within our law that if somebody is in prison or is affected by means of monetary losses of over $50,000, there's case law that says that they should have a right to trial, and this respond to custody, which in some states is now
Every piece of evidence that she allowed, gone.
they are now having trial by jury.
Right, so our Constitution does not provide in divorce actions a right to jury trial. Your divorce and custody hearing was in 2016. This is a post-decree motion to modify. Your request for a jury trial is denied. All right, in addition to that ruling, NRS 48035 says that evidence of another act or crime which is so closely related to an act in controversy or a crime charge that an ordinary witness cannot describe the act in controversy or the crime charge without referring to the act or the crime shall not be excluded. Here, my evidentiary ruling is based on those three things: the language of thunder, NRS 48035, the spirit of that, the spirit of the statute. These are the same parties. This is the same act. They have so much relation to each other. Mr. McDonald is charged with telling me what has changed since 2016, and I think that the court really specifically needs to hear about these criminal cases and the acts. He certainly asked plaintiff about all of these acts in his 3-hour examination. You got into those things. You certainly opened the door. You can now not try to take advantage of a legal loophole that you charged right through with the plaintiff. So counsel, continue. I'll allow it.
So going back to Exhibit I.
Yeah.
And that was a criminal complaint filed on October 6, 2016 regarding a violation of a temporary or extended protective order against domestic violence, correct?
That's what it says.
Okay. And that was for an incident that occurred on August 21st, 2016, in which you arrived, you were within 100 yards of the Canyon Ridge Christian Church, correct?
Now there was an order saying that I was not to find another church.
But this complaint
and
is
I
in
was not
regards
at.
to you being within 100 yards of the
I
Canyon
was
Ridge
confused
Church.
under that order. There was a date. There's a separate entity from Canyon Ridge. There's an actual auditorium, and then there's a daycare, which is within over 100 feet. And that was what I was confused about, and I was
But
going.
if we look just at the complaint, it was regarding you being within 100 yards of Canyon Ridge Christian Church, correct?
That's what it says.
Okay. And I'd like to admit this criminal complaint as plaintiff's first trial exhibit, Your Honor.
Any objection?
That this has been adjudicated. Well, it's still on. I don't believe this has relevancy to this case because it shows that it's just a more poisoning of the well to show what happened. I mean, it's up to you, Judge.
Okay, I'm going to allow it. You certainly questioned plaintiff about it for some time about the event. I think it's appropriate. It'll be admitted.
And based on that complaint, you were sentenced to you received a suspended sentence of 179 days in jail for that charge, correct?
I was thrown in jail for over 5 days and missed out on a business trip to Canada, and I was almost fired from my job because they didn't know where I was at. I wasn't even able to make a phone call.
Okay, I will refer you to Exhibit D. It's a register of actions. Case number C1162845A. And it's been marked as plaintiff's exhibit. It's base stamp PLA 000206. See that document?
Okay. No contact with the victim. I had no contact with the victim.
If you look at the 11th item down that's dated 12/8/2016, does that say sentence suspended jail 179 days?
Yes, that does say that.
Okay, and if we look further down,
It also says broad due, so stay out of trouble broad.
and then we look further down towards the bottom of the page, date 1/12/2017, it says revoke, and then right under that sentence, jail 179 days, correct?
It does say that, okay. And there was more than 2 days credit time served, but
I would like to admit that as plaintiff's second trial exhibit.
The objection?
under NRS, that statute that I stated, the 48125 sentence 2, that this was a no low contendere plea. It was Mr. McDonald, I did not understand the implications of pleading that. I didn't know I'd lose my appellate rights, and also I did not understand the broad stay out of trouble order, as I've never been in any criminal proceedings or in trouble with the law before. So I would say object to it based on that.
But you concede that you were sentenced to 179 days on January 12, 2017?
For the phone call, yes, Judge.
All right, and you agree that you pled nolo? Is that correct?
To the phone call?
No, on 12/8 you pled nolo. Is that correct?
I believe so.
You found guilty? Is that correct?
No, Judge, that's not correct.
You were not found guilty?
That was NOLO is not pleading guilty to.
No, you were found by the court
Oh,
and
is
adjudicated guilty.
Yes, Judge.
All right. You were ordered to stay out of trouble. Is that correct?
A broad, yeah.
All right. And 179 days were suspended.
Which I did not understand. Yes.
Okay. And you were supposed to stay away at least 100 yards from the victim. Is that correct?
Yes.
I'm not going to admit it based on your objection.
Then back to Exhibit J. And again, have you seen this document?
Yes.
And what do you understand it to be?
Criminal complaint.
Against you, correct?
Which, yes, I didn't understand, but yeah.
Okay. And if we look on the document, count A is for a violation of a temporary or extended protective order against domestic violence, correct? And count B is battery, which constituted domestic violence, correct?
Yes, which battery, anything can constitute domestic violence. It's very vague in our statutes.
And this was filed against you on November 30th, 2016, correct?
That's what it says.
And it was based on an incident that occurred on November 11th, 2016.
How many
And we
football
talked about
fields
it
is
then
that?
today, correct?
Veterans Day, when the kids didn't have school, yeah.
And did you go to trial on these charges?
I was unaware of it being a trial, and there was no process of law, and that's on appeal right now. And
Were you adjudicated guilty of these charges?
I believe I was.
I'd like to admit this criminal complaint as Plaintiff's Exhibit 3, Your Honor.
Any objection?
This should also pertain to that, I believe, as it was already, or maybe
Well, you went to trial on this case, right?
at the time I did not understand it was trial, but yes, Judge.
Did you have a lawyer?
I had a public defender
Okay.
that didn't present any evidence.
Okay. And you didn't know it was a trial?
No, Judge.
Was there witnesses?
Only her parents are witnesses.
Okay, so there was witnesses.
I asked for due process to have witnesses.
Was there a judge there?
Judge Almasi was there.
Okay, and you had a lawyer.
Public defender, yes.
Do you know that a public defender is a lawyer?
Yes, Judge.
Is there something else that they are? I mean, you say
No.
you keep correcting me when I say.
No, Judge, there was also a bar complaint issued on that particular Julian Gregory.
Okay. But you did not understand at all that it was a trial?
No, Judge, he did not prepare me for trial. I sent in evidence and things, but there was no means that I did not know it was a trial.
Okay.
I was also moving my whole building from my old office. We moved to a 25,000 square foot building. I was completely engrossed in that. So at the same time as this going on, I was in charge of buying all the IT equipment, doing all the move and stuff. And
Okay, so I'm a little bit concerned. Do you know what today is?
today is an evidentiary hearing
Okay, what does that mean?
that you make determinations based on evidence of in this as regards to custody.
Okay, do you have any questions about what today is?
No, Judge.
Are you sure?
I don't want to take up the court's time.
No, I want you. You're on counsel's time, and I'm taking it up. If you didn't understand that that was a criminal trial, I'm worried about your competency to be here today, all right? And if you understand what today is. So that's why I need to know, for my own benefit and for your benefit, whether or not you understand what's going on today. Do you want... Is there anything that I can explain? Is there any question in your mind?
Well, there is one question, Judge. I would ask that there's a concern of jurisdiction of what family court and municipal court had, which I was not present to or know, and maybe Judge, you can clarify, is that there was orders issued into this court.
Mm-hmm.
Yet it was there, and per your order, you said any violations of my orders you receive 25 days in jail.
Mm-hmm.
Now, supposedly those orders were violated, yet they were remanded to a criminal matter, and which you can do up to 179 days for, which I attended and happened. So what I ask is what, and there's another thing, that it was also under the jurisdiction of the Supreme Court, especially in regards to the custody when I had the children every weekend or every other weekend and then Hardcastle denied those visitations. So
Okay, so what is your question?
so the question is jurisdictionally, does the criminal court have jurisdiction over family court orders?
I think what you're asking is it a crime to violate the temporary protective order or extended protective order? Yes, that's a separate crime for which the Las Vegas Justice Court, the Las Vegas Municipal Court has jurisdiction. Do you have an objection to my jurisdiction today? Is that your question?
Well, Judge, I would ask do we have jurisdiction over criminal matters here in family court? And especially, and if it was under Supreme Court rule, or it was under pending Supreme Court, did Judge Hardcastle have the authority to, or the jurisdiction?
I can't be your attorney. I can't give you legal advice. I'm concerned because some of these topics are really complicated. And if you didn't know you were sitting through your criminal trial, okay, then I'm worried that you're not going to be able to understand my answer to your question. My answer to your question is not relevant today. If you have an objection to my jurisdiction today, hearing this family case, it's denied. I have jurisdiction. My jurisdiction is continuing over this custody matter. You filed your motion here. You submitted yourself to my jurisdiction. Your children live within the county. You live within the county. You live within the county.
Country's going to hell in a handbasket. Hell in a
I'm proceeding
handbasket.
today. I can't answer all of your questions about all of your interactions with other courts. I'm not sure that it's very relevant to what we're doing today.
Okay, that's
But you understand beyond that what we're doing today and what's going on here.
there should be a determination of custody based on evidence presented to your...
Okay. All right. Counsel, continue.
And so you admit that you were adjudicated guilty of count 1, violation of a temporary protected order, and count 2, battery constituting domestic violence, with regard to the criminal complaint that's attached as Plaintiff's Exhibit 3, correct?
Which is on appeal currently. Yes.
Okay. But you were adjudicated guilty. And you were sentenced to 25 days in jail, correct?
For the domestic violence, for supposedly pushing.
And with a suspended sentence of 179 days that was concurrent with, consecutive with, the other violation of protective order, correct? Were you ordered to complete domestic violence classes?
Yes, there is an order to complete domestic violence classes, but they're all...
How many were you to complete?
This is a first offense, and I was I was told to complete 52 domestic violence classes within 3 years.
And so far, you admitted as one of your exhibits that you, while in the Las Vegas Municipal Court, while in jail, you completed 15 classes, correct?
While in jail, yes.
And you have not produced any evidence to show that you've completed any additional classes, correct?
So before I came to this court, I tried to get documentation from SafeNest to show my 10 different classes there. There was some that did not count as I was a few minutes late to the class.
Okay, but you've produced no signatures, no registry sheets,
They didn't-
nothing.
They said I had that
Isn't
the
that-
court
isn't
would
that
already
correct?
have that. So I believe this court should be able to pull those completed.
You did not produce those, correct?
I produced a SafeNest booklet that shows that I am attending those classes that don't have a registry.
Where on that booklet does it show that you are attending?
If you look on page 6, that is the alternate to domestic violence. That is the book from SafeNest, which I.
But where on that book does it show Michael McDonald was present on this day for this class?
What I was told from SafeNest is that the court had access to that information. and
But
that
you did not
they
produce anything for today's hearing showing that you've attended any additional classes, correct?
They would not provide that to me. And my counsel did not subpoena that. Our previous counsel.
Were you also ordered to complete a domestic violence level 2 class?
Not that I recall. An intake? Is that what you're... There was an intake done at SafeNest. The one that was in municipal court was too expensive. I was told by my previous counsel to go to SafeNest and complete it, which I have done. And I've also
But
done...
again, you haven't produced any evidence to show that you've completed or taken any additional classes,
I was
correct?
told by SafeNest that you guys would have... the court would have access to that information.
Okay, but you didn't produce anything, correct?
No, I was unable to.
I'll have you turn to what's been marked as Exhibit K, Plaintiff's Exhibit K. Have you ever seen this document before?
I don't recall, possibly.
Okay, and what do you understand this document to be?
I was supposed to get out of jail in May of 29th of 2017, and the plaintiff went and filed more things, journal entries and text messages.
I'm going to ask you to just answer the question. What do you understand this document to be?
This is a criminal complaint on text messages of how I can get presents to my children.
Okay, so this is a criminal complaint filed against you, correct? And if we look at the second page, it's date stamp PLA 000218. Up at the top it says it's dated February 8th, 2017, correct?
Okay.
And this is based on an incident from December 24th, 2016 and January 3rd, 2017, in which you were charged with violation of a protective order for repeatedly and continuously attempting to contact her via text messaging and or phone calls and or attempting to contact said applicant via texting said applicant's parents and attempting efforts to contact her.
I would
That's
ask-
what the complaint says, correct?
Okay. I would ask that this be precluded based on NRS 48-125 as this was a no-low contender, as I didn't want to. I had 179 days suspended over my head, and I took a plea deal just to not be able to not to go back to jail. I had to get bailed out by my parents for $5,000 after that. When I was supposed to get out, they kept me in an additional 10-15 days, and I was bailed out, and then I took a plea deal.
Okay, but this
Hold on. So my same ruling stands. Let me, as I've looking at other cases, also indicate that it talked about Taylor versus Thunder, but Pasadena police officers versus Pasadena 51 Cal 3rd 564. evidence of a no-low plea is admissible in subsequent civil proceedings consistent with the terms of NRS 48035, which states evidence will not be admissible if its probative value is substantially outweighed by the danger of unfair prejudice. Moreover, 48035, evidence of another act or crime that is so closely related to an act or controversy or a crime charge that the ordinary witness cannot describe the act in controversy or crime without referencing the other crime shall not be excluded. Mr. McDonald specifically opened the door to these instances by his questioning of the plaintiff at length. They were not passing questions. He questions her about the specifics of each of these actions. He has brought up to this court and indicated part of his argument has been his time in jail, these criminal cases. He's given us pieces of paper about the silver bullet, and his whole argument, your whole presentation today revolves around these criminal cases. And so it is absolutely relevant. You've opened the door. I think the case law and the statute support this decision clearly and unequivocally. Counsel, continue.
Counsel, you can't continue. I'm sorry. Don't worry about that. They're fine. They're fine. One just got a little too close to the other cat, and they don't like that. They like their space. So, we're going to end this today. Pick it back up tomorrow. I have it automatically redirected to OJ. I hope to see you there. The case is getting really, really, really good. It's way better than I thought it was going to be. But that's why it's the trial of the century, right? All right, guys. Thank you so much for coming out. I'll see you in 2 minutes. Anthony doesn't know how to make breakfast. Bye, guys.
Got these lights that goes digital dreams through the screen. Her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a wake, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh